name is Jennifer Olmstead. I am the Senior Director of Governance and Operations here at the San Diego County Medical Society. And in partnership with the Doctors Company, I would like to welcome you to our last webinar of 2023 entitled Strategies to Enhance the Patient Experience and Reduce Your Risk. Our speakers from the Doctors Company tonight will be Kathleen Stillwell, who is the Senior Patient Safety Risk Manager, along with Richard Cahill, who's the Vice President and Associate General Counsel. And now I'd like to introduce Kathleen Stillwell. Kathleen?
Our program strategies to enhance the patient experience and reduce your risk. And this program came about because we have seen such an escalation of grievances filed with health plans by patients who are unhappy when the office doesn't give them what they want, when they want it, and how they want it, and an increase in reports to the medical board. I'd like to start with a bit of inspiration. And for tonight's program, I look to what Bill Gates said, the founder of Microsoft, co-founder. He said, your most unhappy customers are your greatest source of learning. And actually that's true. And even for you in your practice, your most unhappy patients are your greatest source of learning, either to validate what you're doing is good and working, or to say, this, we get a lot of comment about this or that, maybe we should reevaluate. Not going to go through the objectives on this, but I want to get to why are we even talking about this? Well, you know, patient experience ratings are driving healthcare plan provider selection, and it greatly influences a consumer when they're providing a choice to pick a provider for a specialty, for primary care, whether they're in an HMO, a PPO. They're looking at the network providers. What do people do? They look at the profiles. They go on social media. They ask their friends. They ask their neighbors. Another thing that I want to share with you tonight, because I found out so many physicians have no idea. You might be in a practice where your own practice does a formal patient experience survey once or twice a year. If you're in a large group, they may be using Press Ganey or some other very large commercial patient experience ratings. But I'm going to tell you that anyone who's taking care of Medicare patients, including Medicare Advantage, those Medicare patients are getting the Consumer Assessment of Healthcare Providers and Systems survey, and I call that the CAPS survey. And the reimbursement formula for reimbursing networks for Medicare payments is based in part on the provider results of the CAPS survey. I have so many physicians who said, I never had a clue, I never even heard of that survey. Negative consumer experiences are increasingly resulting in adverse comments on social media. That's a problem. And health plan grievances and patient complaints to the medical board have increased at an alarming rate over the last 12 to 18 months. And we see that. I did want to say something positive. Look at the most recent Gallup poll available from 2022 on the question of honesty and ethics ratings by profession. So at least you think everyone thinks you're not doing a good job. No, the public thinks you're doing a great job. We know you're doing a great job. But look at this. Overall in the country, and every year for the last 16 years, medical doctors have been at the top. Yes, I see nurses are just a little bit above you, but not much. The public is biased in favor of you. But I'm going to tell you that the health plans and the medical board are not in the same. I mean, they believe that you're honest and ethical, but they're consumer driven. And just for the heck of it, I have to point out that members of Congress are next to the bottom on the list. So why do patients and what do patients complain about? This is what I went through a number of survey research, and here's what came up. Number one, I waited too long to get an appointment, and or the day I got the appointment and got there, I had to wait too long to see the doctor. Right now in Orange County and LA County, and I'm not sure in San Diego County, the wait time to get a new patient visit with a specialist and even a primary care runs 45 to 95 days. I don't know what it is in San Diego, but people can't get in. Second They said the physician was rushed during the visit and I didn't feel I had time to ask questions. Well, I know that physicians are very conscientious about saying, do you have any questions? But people don't hear that. So be mindful of that and say, at the end of I'm going to ask you if you have any questions, and then you can repeat them back to me. Tell them at the beginning, you're going to ask them at the end. They don't remember you asked that. And then at the end, as I said, I wanted to see if you had any questions. Now, one problem you have is patients want to have a bunch of questions and you're out of time. You had a 15-minute visit, a 10-minute visit, a 20-minute visit. What you have to say is, that's a good question. And what I'd like to do on your way out, please schedule another appointment for a follow-up. And I'd like to address those issues in the next appointment because I wasn't expecting that today. And this visit was booked with not enough time to go there. The other thing, what they're complaining about, would you believe that you won't give them a telehealth visit? At the beginning of COVID, we had so many complaints. Doctors calling and saying the patients won't come in the office. I have to do telehealth. I have no staff. I'm doing telehealth from home. And patients were upset. I don't want to do telehealth. That was in March 2020. Now they don't want to come in the office. They only want telehealth. And you need to have.
I apologize for interrupting, but it appears that we are still stuck on the Gallup poll slide. We have not moved forward.
You're on what slide?
We're still on the Gallup poll slide. It has not moved forward to the patient's complaint slide.
Let me move forward. Did it move forward now?
It did. We're there. Thank you.
Okay, thank you for letting me know. Stop me if it happens one more time, I'll have you bring your slides up, please.
Sounds great.
So the thing about telehealth is, general speaking, you want to see a patient at least once a year in person, especially if you need to evaluate their physical being. And so that's a good standard to have. And if you're refilling medications, best practice is that you see them at least once a year. During COVID, we had to stretch that a bit. But now people say, I don't want to come in. Just give me another refill. I don't need this. I don't need that. I'll go get the labs and you'll get the lab reports, but I don't want to come in. So we see that, what patients are complaining about, that they can't come in for a telehealth visit. So part of that is educating them to why I have to see you once a year. This one I thought was interesting, and I lumped it into one category. Provider was impersonal during the visit. And these are the things patients said. And this is in an assortment in solo practice, small group, big group, large group, huge group. The same things came up. The provider never used my name during the visit, did not use eye contact, was distracted, looking at their watch, looking at their phone. And I know even as I'm on this call, my smart watch is vibrating, but I'm not stopping to look. Someone's trying to call me. My phone's turned off, but I'm not going to stop and look. And look at the next one, interrupted by staff during the visit. Your staff should be told, do not interrupt me unless it is a real emergency. And an emergency shouldn't be that something, if it's a colleague calling, your spouse, your friend with benefits calling, that's not an emergency. Although I have doctors that tell me with people in my life, it would be an emergency if I didn't take their call. But you got to be judicious about it. And then the physician or the provider, because they use the terms interchangeably, left the exam room twice during my visit to take a call. That's a lot. And so one of the things is, if you think you might be getting a call at the beginning of the visit, you say to the patient, I'm expecting an important call and I want to let you know if it comes during this visit, I will have to step out for a moment. And you've cued them to be aware of it. Did my slide advance, Jen?
It's still on the patient's complaint about. Oh, it has just moved forward. Yes.
All right. So what are problem areas? What we see as problem areas for the patient experience is a poor experience with office staff on the phone or in the office. And that isn't because of your staff usually, it's because of the patient. The problem we have is that the patient is rude, inappropriate, or uses inappropriate language or makes comments that are inappropriate, and they don't get documented in the medical record with quotation marks. And then we have no rebuttal documentation for the grievance or the complaint to the medical board. So it's very crucial that your staff is aware that they need to document that. Other things that come out in the surveys that I reviewed is that patients felt like a number. And this had to do with what would make you not feel like a number. Well, if they used my name, if they looked at me when they're talking to me, if the office used my name, the office staff. And then, of course, communication issues can relate to language challenges and health literacy. Those are two different issues. Health literacy can be a patient with 3 college degrees who can't process healthcare information. So be sure you and your staff are not talking about whatever's going on in acronyms and in the vernacular healthcare language so that they have a sense of what you're talking about. Language challenges, you should be using a translator. A guest or family member with the patient does not qualify as a translator. The 21st century landscape, and I'm only looking right now, these are all the boxes that make it up, but I'm just focusing tonight in our program on the consumer experience. But look at how many other areas impact the patient's experience. Do they feel like you're inclusive, or you have gender sensitivity?
Kathleen, the slide not move forward.
Okay, let's have you bring the slides up, and I'm going to stop sharing, Jen. And we are on slide 12. And I apologize for this.
Bear with me 1 second while I get those up. Okay.
Can you make it full screen?
There you go.
Right, so there we are. Thank you. So we're just looking tonight at the patient experience. Next slide, please.
Okay.
Cultural competence. I'm not going to say too much about this slide because I think it speaks for itself. Jen will also make the slides available to everyone. In order to get CME credit, we have to include cultural linguistic competency and implicit bias content. But I do want to look at the bottom left box, recognizing attitudes towards differences. You are culturally diverse in your population of patients, and you and your staff are culturally diverse. So we don't see issues about this coming about. Even in our claims, we don't see it. Our physicians that are out there are embracing and inclusive. And so thank you for that. That's an important part of the success of your practice. On the next slide, I'm going to look at the patient experience, encompassing interactions, not just with you and your advanced practice practitioners and office staff. Look at how many other encounters the patient has. And when they answer these surveys, these are things that they have in their mind. Did I get timely appointments? The ease of access to information, because these are all the areas that are asked about in these surveys. Did I have communication with the providers and staff? Do they follow up with me? Does anyone from the practice follow up with me? Do I have access to the EHR? That would be, is there a portal? Or we see, well, I didn't even know there was a portal. They have a portal, but I don't know how to get in the portal. Nobody told me how. And then when I talk to practices, they say, when people come in, we say, here's the instructions. We'll send you the link. Call us if you need help. But people don't ask. And most people, by the way, don't seem to want to get in the portal, but we do see an increase in portal access, especially with senior patients. And it is apparently related to their family members, their adult children. They're getting the access and the permission to the portal by the patient. They want to see what happened at the visit. And then, of course, in the survey patient experience, they're also asking about telehealth visits and phone calls. On the next slide, I want to show you some questions, just a few of the questions in this CAPS survey. So if you have Medicare patients, these are what they're asking. I'm not going to read them all, but look, did you start on time? Did the provider listen carefully, show respect? Now, I want you to see the answers. The choices are all, there's 3 choices. Yes, definitely, yes, somewhat, and no. So in question 22, staff at the provider's office may talk with you about your visit, help set it up, and remind you about appointments. Did you talk to staff from this provider's office? When we know that there's staff calls and even makes reminder calls, people will still mark this no. Go figure. So it's really a hard survey to do well in. Let's go to the next slide, Jen. This is the last question on the survey. And I wanted to show you this one because I think it's a really important question. What number would you use to rate your most recent visit? 0, worst visit possible. 10, best visit possible. Of course, you'd like to get a 10. What I find interesting is that looking at the survey results, even if patients said yes some of the time on those questions, when it came to rating the most recent visit, I would see a response of 6, 5. It's really hard to get a 10 on this. Now, I know that CMS knows that, but patients aren't very gracious in these surveys. Now, the next slide talks about some, if we can move forward, please. Communication strategies to enhance your patient engagement. And before I get into it, I want to tell you there are 3 intersections of time that you encounter the patient and the patient encounters staff in your office. They are the 3 most critical times for you to enhance the patient's experience. When is it? When the patient is greeted on the phone, when they're greeted when they come into the office by the front desk, when the MA greets them and onboards them in the room or onboards them to a telehealth visit, and when you come in and greet them. Those are 3 different greetings they will have if they're an in-office visit. It will be less, of course, if it's a telehealth or just a phone call. That is critical. What is the most important thing to do? If it's in person or on the phone, use their name and teach your staff you need to say the patient's name. If I say, hi, this is Kathleen Stillwell, I'm calling, I want to make an appointment. Okay, Kathleen, how may I help you today? Is this a first appointment? Yes, it is. All right, thank you. And then at the end of that interaction, that person should say, thank you, Kathleen, for calling today. We look forward to seeing you on date. So it's the greeting and it's how you say goodbye, because the second intersection that is most important is how we say goodbye to people. And we say thank you. That's the third thing people want to hear. They want to hear thank you. Thank you for coming in. Thank you for choosing us. Thank you for being on time. And we wouldn't say that. Thank you for not being late again. Thank you for not canceling again. We don't say anything negative. It's positive. So you want to train your staff, greet people with a positive affirmative statement. When they walk in the door, no one should be asked, how are you doing? I'm coming to the doctor's office. I'm sick or I'm treating for something. Instead, greet me and say, good morning. It's nice to see you, Kathleen. Well, or welcome back, Kathleen. I'll sign you in. So we don't want to ask people, how are you? That's the doctor's question. How are you? That's different. So greet by name. And if you have a non-English speaking person, please use a translator. Focus on the question for today, the reason for the visit today. Again, we can't get off on a tangent. You have a very tight time frame. And then saying goodbye, thank you, and use the patient's name. I want to say something that the research shows what patients like. How do they like you to say goodbye? Well, years ago before COVID, a lot of people shook hands when they said hello and meet a person and greet them. With COVID, we gave up handshaking and did knuckles bump, elbow bump. That isn't what they like. You know what they like to say goodbye? The doctor or the advanced practice provider, 2-finger touch on the shoulder. Thank you, Kathleen, for coming in today. I'll see you next time. Thank you, Kathleen. I'll look forward to seeing you next time. It was good to see you today. I'll look forward to see you. Just a tap on the shoulder. Nothing more. Simple. Keep it simple. The other thing that's really important in the strategy for you to use is your nonverbal skills. What is the best position to be in? Sit down, eye level with the patient, lean forward a little bit and use eye contact. No crossed arms. I can't do it in my video. No hands on hips. Those are all more assertive, negative behaviors as viewed by patients. Don't check your phone and watch. And every so often nod when the patient's talking, so they feel like you're listening. Okay, go on. That's good. Let's go on to the next slide. If the patient had to wait and you know it, it's a good idea to say, I'm sorry, there was a wait. We had an emergency today. You can just say it was emergency. You're late, get back from lunch, you had a phone call. You don't have to say what it was and say, oh, what happened? Oh, I'm sorry, because we follow privacy rules, we can't discuss it. But it shows that you care and value their time. And one of the things is you get a lot of names that are difficult to pronounce. And a lot of physicians will tell me, I don't use names because I don't know how to say their name. I said, well, okay, this is a good thing. When your staff rooms them, they should say, get their name. And if it's not clear how to pronounce it, have them write it phonetically for you on a piece of paper before you go in the room, or give it to you, or have it in the room so you can say it phonetically. Or say to the patient, if you don't know and no one told you, I want to be sure I pronounce your name correctly. Could you say it for me? And they might say, just call me Jane, or just call me Tom. That's okay, but just ask. And of course, listening is good. Visit summaries are great to give it on the handout at the end. That can be difficult. If you're using an EHR, sometimes you can't get the visit documented till later in the day, and it'll be in the portal. Let people know. Refer, or have the MA always tell people when they leave. Remember, the doctor's notes will be available in the portal after 5 p.m. today or within 24 hours, and you can visit the portal. That's very helpful. The next slide shows some information that I think is really important for you to hear and understand. And that is that research shows the third leading contributing factor in malpractice claims nationwide, with the doctor's company and with all the other carriers that have studied this, communication is a problem. And it's not just communication with the patient, communication with the patient's family, communication with your staff, communication with other providers, with specialists, your staff's communication problem with the patient. It's all lumped together. But this study, I think, really bears sharing. The study was done where the patient was leaving a medical office building, and they were asked if they would engage in a very brief questionnaire, that they would be intercepted in the lobby of the medical office building and asked 3 questions. 24 hours later, they would agree to a phone call to be asked the same 3 questions. And they had several specialists on this floor: surgeon, endocrinologist, allergist. There were different ones. The participants were age 18 to 80. At the conclusion of the study, when it was all said and done and the analysis of the results, the study determined that 80% of the information people got in the doctor's office, they left, and less than 5 minutes later, they were in the lobby. They could not answer the 3 questions. The 3 questions were basically, why were you seeing the doctor today? What did the doctor tell you? And what was most important about what he told you or she told you? 80% of it, they couldn't answer. They were left with 20%. They couldn't answer it. 24 hours later, they could only recall 10% of the 20%. So you see, if you think about it, patients aren't going to remember what you said, but what they remember the most, listen for this, how they were greeted and how you said goodbye. Everything else to them was noise and information. A patient might be asked by their family member, what did the doctor say today? I don't know. He said I had to come back in 4 weeks, which was what was said at the end. What else? Well, I don't know, but did they tell you anything? Don't they tell you anything in the doctor's office? Well, they do. They have the nicest staff. I love going there because the staff and doctor are so nice. But people don't remember what the conversation was about. So one of the things when you're telling a patient something, maybe you have 3 important things to tell them. And a lot of times we find that people will say, the first thing, the most important thing I want you to do is number 1. And then I want you to do number 2 and 3. Studies show that you should say the most important thing last, not first. And if you have teenagers, you know this. I'm going to tell you the rules tonight if you're going out. And I'm going to tell you the most important one last, so be sure you're listening. First one and third, you better be in the house by midnight. Now, I want you to tell me what's the most important thing you're going to do. And you ask for a repeat back. And that's how you get people to demonstrate that they heard what you said. My last slide is next. And this is just to show you some data from our closed claim study. If you can advance the slide, please. Jen? Our closed claim study looking at the percent of patients in closed malpractice claims that said that they were dissatisfied with care. And the top factors contributing to the patient dissatisfaction fell into three categories. We've already, first one, patient factors, where they were seeking other providers because they just said, I didn't like what this doctor was doing or the outcome, so I went and found another doctor. Poor rapport, which included a lot of commentary about no empathy, no sympathy response to the patient. Now, that's a personal thing, and a lot of people don't feel it. Even if you said it, if you cried with them, they wouldn't know that you were being empathetic. But look at the one I want you to see is on the far right, 24.5% of our closed claims, there was a communication issue between the patient, family, and provider, and it was about expectations. And the patient's expectations weren't met. They didn't feel they were provided the information they needed. With this now, I'm going to transition to Rich Cahill. Our next slide, if you'll move forward, does communication impact medical malpractice litigation? Rich?
Thank you, Kathleen. Good evening, everyone. My name is Richard Cahill. I'm Vice President and Associate General Counsel with the Doctors Company. As of this past August, I have spent 40 years defending the healthcare community in various types of litigation and also in various forums, whether it's administrative, the civil courts, and so forth. My next slide gives you the basics of what constitutes a professional liability claim. Next slide, please. It looks very simple, but it's actually pretty complicated. The first question in a professional liability case is there a duty to provide care consistent with the community standard? In the vast majority of circumstances, it's clear when someone is your patient, and it's determined by objective evidence in most jurisdictions. In fact, I wrote an article earlier this week that will be published later this month in Healthcare Business Times, and it deals with these various issues. And if the individual is your patient, you have a duty to provide care consistent with the community standard. What exactly does that mean? It means that would a similarly trained practitioner under same or similar circumstances do what you would have done? And if so, then you're within the community standard. It's also determined by the totality of the circumstances and not with the benefit of hindsight. There are two outliers to this. One is curbside consultations. And part of my article that I wrote dealt with this because it's a collegial part of the practice of medicine and has been for several generations, where an individual will go up to a consultant and try to get a quick assessment of what's going on. There are pitfalls associated with that, and I encourage you to review an article that I published last April on this very topic, because sometimes it can be very problematic. Did you get enough information? Did you set boundaries clearly at the beginning of the relationship, or as to what was expected? And if you don't have enough facts, you can't realistically provide a reasonable response. And so therefore, the more of the following questions that you answer yes, the greater the likelihood that it will be determined objectively. In other words, what would a reasonable person have anticipated the relationship was, that a physician-patient relationship existed. What information was the consultant provided? And undoubtedly, the consultant won't remember the encounter 2 or 3 years later if an adverse event occurs and a lawsuit is filed, because inevitably with curbside consultations, the consulting physician did not make a note anywhere. Most likely, the person making the request for a curbside consultation, will record it. I spoke with Dr. Stillwell. She advised me X, Y, and Z. And you have no way of recalling this because you have no record of it 2 or 3 years later, and you have to rely on habit and practice. And frequently, as Kathleen is fond of reminding us all, if it wasn't documented, the plaintiff's attorney will say that it wasn't done. So, did you actually see the patient? Did you review the medical records? Did you order any tests, imaging studies, laboratory studies? Those are the major issues involved. And did you order any therapies? But the most single important issue will be whether you, as a curbside consultant, submitted a bill. Because as we all know, if you submitted a bill, it means you actually provided care that was appropriate under the circumstances, it was delivered, and that the amount of reimbursement sought is consistent with the services provided. And so if you send a bill, inevitably the curbside consultation will be regarded as having created a duty. And the duty is, did the care that was provided comport with the community standard? The second issue is breach of that duty. And how is that determined? In our professional liability cases, it's determined by independent expert testimony. The plaintiffs frequently retain independent experts from academic medical centers to come in, tout their various impressive qualifications, to say that they're familiar with the community standard, and to say that either by omission or commission, the provider failed to comport with what was being done in the community. When I first started doing this work in the early 1980s, it was a regional or even a local community standard. Now, with the advent of that, it's a national standard. So you would expect what is done in Beverly Hills or San Diego would be the same thing that is done, for example, in Bakersfield or the Central Valley of California. Defense experts tend to be community-based physicians. And when I was in private practice, my 3 principal clients included Cigna Health Plans, Kaiser Permanente, and Tenet Hospitals, which was then and still is the second largest for-profit hospital chain in the United States. And I would get community-based physicians because they, in my mind, have a better sense as to what's being done in the community and what their colleagues are doing and would have done under the same or similar circumstance. The third component is causation. Is there some causal relationship between the omission or commission that the plaintiff claims was negligent and a compensable injury? In California, we follow the traditional approach, and that is, to a reasonable degree of medical probability, did the alleged breach in the community standard cause an injury that the plaintiff is seeking payment for? Unfortunately, over the last 2 decades, 24 states have changed that and lowered the bar substantially to the loss of chance theory, which says that if the plaintiff can establish that he or she was denied an opportunity to be cured or denied an opportunity for a better result, then they can recover. So no longer is it a standard of care issue having to do with reasonable medical probability. It's a much lower standard. And the most recent state to have adopted this approach was Oregon, approximately 3.5 years ago. But fortunately, we still have the much, much higher standard. One of the leading plaintiffs' attorneys, when I first started doing this work, told me that if he had a sympathetic patient, a lot of damages, and some negligence, he would prevail. And maybe that was true for him, but certainly that hasn't been my experience. We win between 75 and 80% of all claims that are brought in which we have a favorable jury verdict, a favorable arbitration award for the provider, or the case is just dismissed for one of a variety of reasons. As Kathleen indicated, there's a very strong bias in favor of the healthcare community, and that's a good part of the reason why we prevail. And in my experience, the care that's presented is very good and consistent with the community standard. And then with the added bias, it makes it a very difficult hurdle for plaintiffs to overcome. The final component is damages, and those fall generally into 2 categories. General damages, which are pain, suffering, loss of enjoyment of life. I have a scar, which I'm going to have for the rest of my life, that sort of thing. And the second is economic damages, and these are generally past, present, or anticipated future out-of-pocket expenses, which may be loss of earnings, earning capacity, medical specials, and so forth. So those are the four principal things that we see in our professional liability case. Some of you may recall that about a year and a half ago, the plaintiff's bar was successful in working with the legislature and the governor to change the damages component. When MICRA, the Medical Injury Compensation Act, was passed in September of 1975, it put a lot of very significant benefits of tort reform in California, which includes the damages cap of $250,000 for pain and suffering, a very clear statute of limitations. It imposed caps on attorneys' fees that made it less incentive for plaintiffs' attorneys to pursue these cases. Also, with future economic losses, those are paid on a periodic basis. And the plaintiff's bar for many years tried to fight that. The first thing they did in the 80s and 90s was to go to the appellate courts and say that this was unconstitutional because it treated plaintiffs in malpractice cases differently than they would, for example, in a products liability case or otherwise. The legislature was supported by the appellate courts for more than 20 years and still is. The next thing that happened was that Governor Gray Davis, when he was running for re-election, said that he was very favorable to increase the damages cap from $250,000 to a much higher level. He was unable to get that accomplished and was subsequently recalled in 2003. The next component occurred in 2014 when the plaintiff's bar, also known as the Consumer Attorneys of California, a very fine organization, attempted to increase the cap from $250,000 to $1 million. That was soundly defeated by approximately 2-1. But this past year, after more than 40 years, the plaintiff's bar and the legislature, in conjunction with Governor Newsom, did make some changes, not as far as duty, breach, or causation, but simply as to damages. Now the damages cap, instead of $250,000, went up to $350,000 and will increase over the next several years at $50,000 a year, up to the maximum, which the legislature has recognized with the new statute. They've also changed the attorney's fees that plaintiffs may recover, instead of it being a sliding scale to disincentivize the attorneys. That has been, in the plaintiff's attorneys, significantly changed. So what will that do to malpractice cases? I think those of us that have worked in this field for many years don't believe that it will change the percentage that we win in the cases, because it did nothing to the high standards that the law imposes on plaintiffs and their attorneys to establish to prevail. But it may increase the frequency because there's greater damages that they can recover. And in the event that they do prevail, plaintiffs' attorneys will receive greater compensation for their efforts. Next slide, please. Jen, could we have the next slide, please?
There you go.
Thank you. As Kathleen indicated, they're most frequently a result of a miscommunication. And it's several components to this. Miscommunication between the patient and the physician or one of the support staff. Miscommunication between the physician and or a member of the family who's been given permission to speak on behalf of the patient. And also potential miscommunications between and among the provider team while they're trying to determine what to do. And these are the areas: diagnostic errors, surgical errors, failure to treat patients, birth injuries, which in my experience frequently present catastrophic damages with regard to past, present, and future economic loss, and also prescription drug errors we see occur as a result of a miscommunication. Next slide, please. And we'll go over this just very quickly. And as Kathleen mentioned, you will be given an opportunity to review the slides, but you'll note that communication is a significant contributing factor for vascular, infections, cancer situations, and total percent as well as the percent of cases. Documentation also is a significant factor, and we'll talk about this later in the program about the importance of documentation. It's the key factor in defending our cases because inevitably, unless there was an adverse event that occurred and causes you to recall a particular visit or hospitalization, most likely it'll be something that, absent documentation, you'll have no way to reconstruct what transpired. Next slide, please. It's frequently referred to as your silent witness. A medical record documents what it is that you did and why. It's admissible independently in court as long as it constitutes a business record, which means that it was done at or near the time of the event for a business purpose. And then it can be admitted, and as part of our electronic courtroom, frequently key documents will be put up on the screen so that witnesses, the court, both counsel, as well as members of the jury panel can see exactly what's being discussed. So it's important to document objectively, avoid personal subjective observations, never point the finger at someone else because inevitably that ends up making the plaintiff's case very easy. If Dr. A talks about Nurse C, inevitably Nurse C will have some comment about Dr. A. The plaintiff's attorney just sits back and says, didn't I tell you they all made a mistake and they were all willing to point the finger at one another? That's not something that over the course of the last 20 years we see very much of, although on occasion we see that nurses will document in the chart certain comments that may be regarded as critical of a provider as to what was said and done. If you see that in hospitals where you practice, it would be worthwhile to bring that to the attention of the medical staff office so that it can be properly addressed so it doesn't become an ongoing conflict. Also, remember metadata. Metadata is forever. And as I'm fond of saying, most of us in the legal community don't have a scientific background, but we can hire people that do. And one of the first things that's done after all parties get a copy of the medical records is to have an IT expert look at the metadata to see if any changes were made. One of the ways that plaintiffs' attorneys have been successful is to say that the record itself was somehow inaccurate or that mistakes were made, and that impeaches the integrity not only of the medical record, but of the individual who is alleged to have made the change. Communication failures may be system issues, and this is another area where plaintiffs' attorneys have been successful, because in most situations, the jury wants to find in favor of the healthcare provider, whether it's a nurse, an advanced clinician, or a physician. But if the plaintiff's attorney is successful in saying, well, there was a system in place as evidenced by protocol 1, 2, 3, everybody admitted that that protocol was in place, but that it was not followed. And in fact, several of the providers testified that they were not aware of that protocol. The experts will inevitably come in and say, had that been followed to a reasonable degree of medical probability, this problem would have been avoided. And that then becomes the plaintiff's battle cry and closing argument to say, yes, we have fine practitioners here, but because there was a systems failure, my poor patient suffered and now is deserving of a jury verdict in his or her favor. So therefore, documentation in the medical record is key. And remember, it needs to be accurate and made at or near the time of the event. One of the first cases that I did many, many years ago, back in the early 80s, involved a situation where a patient, I think it had a Whipple procedure, very significant surgery, and the patient subsequently died. My boss, then as now, was the leading appellate healthcare attorney in the United, or at least in California, and probably in the United States. And he asked me what I thought. And I said, well, it's amazing, but the death summary tracked very closely to the autopsy findings. And then he said, well, look at the dates. And it turns out that the death summary was done almost a month after the autopsy was done. totally impeached the credibility of the records, and the case ultimately was settled because it could not be sufficiently defended by expert testimony. I'd like to apply some of these principles now to a couple of case studies that we've put together. The first case involves a communication failure. The patient was a 79-year-old male with a history of chronic obstructive pulmonary disease, chronic afibrillation, hypertension, peripheral vascular disease. He presented for a fluoroscopic guided intrathecal contrast injection of the lumbar spine for a CT myelogram. The radiologist learned on the day of the procedure that the patient was taking Xarelto for chronic atrial fibrillation. Nonetheless, the radiologist decided to proceed based upon the patient's extensive vascular problems that would exacerbate risk of clotting and atrial fibrillation. Also, there was an increased risk of stroke if the patient discontinued the Xarelto. The risk, benefits, and alternatives of the procedure were allegedly discussed with the patient. The radiologist talked about proceeding because the patient was on an oral antibiotic. Unfortunately, and this is what I was mentioning earlier in the presentation, there was no documentation of any of this discussion in the patient's record. And not surprisingly, the plaintiff's attorney argued if it wasn't documented, it wasn't done. And of course, there is an evidence code provision in California that enables us to present evidence of habit and practice, which is what was done in this particular case, but to no avail. Following the procedure, the patient complained at the injection site, developed an internal bleed in the lumbar area, and developed aseptic meningitis. The patient subsequently developed limited strength in his legs, cannot now walk on a permanent basis, has experienced difficulty with speech, and other neurological sequelae. Next slide, please. What did the experts say? Experts were consulted on both sides, dealing both with standard of care, with the documentation that was done, as well as the causation factor. Did the alleged negligence, to a reasonable degree of medical probability, cause the various limitations that the plaintiff's attorney claimed that his patient experienced? The experts were very critical about the lack of documentation related to the informed consent communications. Inevitably, in a situation like that, the physician involved would be asked the question of, do you regard informed consent as a critical part of your treatment? The answer is invariably yes. And what you need to do is communicate to the patient in clear and simple terms what he or she has, what the various procedures or treatment options are available, what the benefits and risks of each one is, including the potential risks of not doing any treatment at all. Would you agree that that's standard procedure? And that's why you document it in the chart. Is that true? Yes, of course, so that we have a record of that. Do you remember in medical school you were taught if it's not documented, it wasn't done? Yes, but I did do it. This event happened 3 years ago. Do you actually remember doing it? No, but I know that I always do. Very difficult to defend that situation if there's no documentation whatsoever. In this particular case, the black box warning to be off Xarelto for 24 hours was not followed. Difficult when you don't follow a black box warning, and that's true of off-label use of medications. You need to be very careful because otherwise they'll say black box warning sets the standard of care, and there has to be sufficient reason that it wasn't followed. A number of years ago, we saw a number of cases where teenagers were given psychotropic medications and then they committed suicide. There was a correlation between the medications and the suicides. Those cases were very difficult to defend because there was a black box warning. Also, the expert reviewers were critical of a lack of documentation of the entire interaction between the radiologist and the patient. Ultimately, because the defense was unable to provide testimony that supported the standard of care and the causation factor, there was nowhere to go other than to settle the case. The good thing is that in California, as in all but 2 states, before a case can be settled, there has to be signed written consent by the insured physician. Now, if we could, I'd like to talk briefly about case study number 2. It involved a 65-year-old woman who went to an internist complaining of nausea, fever, and there was a dark area in her right eye's field of vision. A physical examination was done, but it did not include, or at least it was not documented, that a fundoscopic examination was done. The physician, based upon the brief encounter, diagnosed viral infection and did not suggest any follow-up instructions as to what the patient should do in the event that certain circumstances developed in the course of the next days and weeks. There was also no referral to an ophthalmologist. Also, the record contained no documentation of any treatment plan, anything other than a reference to there being a viral infection, or what the patient was told, if at all, with regard to follow-up. If you have written follow-up instructions that are given to the patient, that's excellent, and those should be specifically included in the chart so there's no question at any later date. The better the documentation, the less likelihood that a plaintiff's attorney will take a case knowing that he will win only 20 to 25% of the cases. And if a plaintiff's attorney does not prevail, either at trial or arbitration, or reach a settlement, the plaintiff's attorney recovers nothing. Worse yet, the plaintiff's attorney has out-of-pocket expenses such as expert fees, deposition costs, copying of records, and various other discovery that not only do they not recover any fee for their services, but those out-of-pocket expenses for prosecuting the case are not recoverable absent a verdict, arbitration award, or settlement in favor of the patient. Ultimately, the patient had permanent loss of vision in her right eye. The internist failed to note the dark area in the field of vision as being a red flag for potential or likely retinal detachment. The case settled. Next slide, please. So what did the experts say? Highly critical that there was no differential diagnosis. Also, there was no documented instructions on how the patient should follow up and what to look for following discharge from the visit. Failed to refer to a specialist for further evaluation, even though it was a red flag that there was a dark spot in her right central vision. Experts for both sides
Rich, we seem to have you cutting in and out. And I'm not hearing you at the moment.
I can't hear him either. Can you hear me, Jen?
I can hear you, Kathleen. So do you want to take over?
I will. I'll pick this up. We've gone through this slide and it wasn't defensible. Let's go quickly to the next case study. And I think in the interest of time, we're not going to go through the whole thing because it's too long, but it was a 16-year-old playing football with a helmet-to-helmet tackle, and a second player hit his head and neck. Can you go in advances to a couple slides? And I just want you to see the outcome, because this had to do with what the experts said, that because the patient ended up dying and there were a couple of incidents, but the experts differed on the care that they should have received. But the whole thing was that experts, plaintiff and defense, don't always agree, but sometimes they agreed, and they really did agree that this wasn't handled well. But let's go on to the next slide, because that's a pretty detailed case. And we're going to go on to the next slide, which is informed consent is communication. I think we've covered that already. Let's go on. Rich did a really good job of covering that. I don't know if he's called back in. And let's move
Kathleen,
along.
Kathleen, can you not hear me?
We can hear you now. We're on slide 38. Could you pick it up there? We had to skip third case study because of time. So can you pick it up on slide 36?
38, yes. Patient safety issue. Communication of abnormal findings. The patient must be told what he or she has. Also, the importance of what the findings may demonstrate so that the patient is alerted that if A, B, or C is not done, these are consequences that may occur. Also, aftercare instructions are very important. Communication gaps can be between the office and a patient, between and among the various treating physicians and consultants, between a hospitalist and a PCP, between the emergency department and the PCP. Not uncommonly, patients are admitted through an emergency department, and then that information, for whatever reason, is not subsequently communicated with a PCP. We see circumstances which can be very detrimental, where a patient is admitted, lab work is done. The initial lab work indicated that it was negative growth, and after the patient was discharged, then it comes out that there was positive growth. It was not communicated to the family. It was not communicated to the PCP, and we've had cases where the patient subsequently expires, where had that information been timely communicated, proper antibiotic therapy could have been initiated. Next slide, please. Understand the new vital sign, health literacy. And as we've seen so often, somebody may be highly educated, advanced degrees, but just simply doesn't understand the terminology that's being used. And it's important to use terminology that patients understand. When I first started doing this work, we frequently would see terminology that was used that was slang, and it was not common for use either at the facility or within a particular specialty. Don't ask patients if they understand, because what they will tell you is, yes, they do understand, because we would rather do that than look ignorant, or they want to get out of the visit because maybe they have something else to do. And if the visit is prolonged, for whatever reason, sometimes that becomes problematic. Make sure you document that the patient understood the instructions, because frequently they'll come back on an informed consent issue and said, well, they talked to me about some of these things, but I didn't really understand. And if you document that the patient, perhaps it's repeat back or ask me 3, there's various techniques for doing that, you can be successful in defending the case. Also, if you have written instructions, give them to the patient and make sure that they're in the chart. Also, translators are necessary. Do not use a family member or a guest or somebody accompanying the patient. Particularly in the hospital setting, there are many services available, and it's important to use those as appropriate. Kathleen, that concludes my portion of the program, and if I could, at slide 40, turn it back to you, please.
Thank you, Rich, for that great information. I'm going to be very quick to get through a couple slides. What patients want, here's what they want. They want effective communication from you. They don't seem to expect that they have to provide effective communication, but this is what they say they want. Clear instructions is on that list too. Let's go to the next slide. I want to point out that patients go to look at social media. And so internet search, now we see that 57% of healthcare consumers use the internet to search for new providers. So they're looking for what someone else posted about you. Now, every week I get several calls from a physician who's upset that somebody posted some nasty, inappropriate, and wrong something about the practice or the physician. You can't get that taken down. Just want to remind you, thou shalt not ever rebuttal any social media comments. It's a violation of HIPAA. Patients are not subject to are. So you cannot say that this patient is a person is a patient. They sometimes use different names, but you know who they are. So you can't say anything. What you can do, if you're interested, if you're with the doctor's company, call us and I can provide the language that Rich has created. If you want to post something that basically just says, we are unable to make any comment to any comments online, we care about what you think and invite you to call our office. And it's very well worded, and I won't go on more than that. I'm very cautious about having people post it because it's like poking the bear, and then people just come right back and make another comment. So unless it is a matter of national homeland security, the FBI, the CIA, or a threat of violence, the website will not take it down, will not be required to take it down. I want you to see that the third bullet, 13% of people in 2020 never read online reviews or checked their doctor's online presence. And a year later, it was 2%. Well, there's no study out later, but I know people are going online because I get the calls all the time throughout the month. On the next slide, I want to go to one particular part, the last bullet. This is what else do patients want? 76% of Generation Z, and those are people aged 27 to 42. Those are your patients that you could have for many years. They're into high tech, they want telehealth, they don't want to come in the office, they want wearables. I love that they define wellness as anything that makes you feel good. But when you see the fact that 40% of patients want virtual healthcare in their homes or offices, get prepared for that.
Rich, do you want to refer to these two articles that you talked about briefly?
Yes, thank you. Non-compliant patients increased your liability, and it's very important that you identify them early on. And it's also important that you document, in this article that appears first I wrote last year, they increase your liability, but as long as you document it, the case can be defensible because, as I found in so many cases, both for Cigna and Kaiser, patients can be non-compliant. But as long as they've been told, and as long as it's documented, patients have a right for self-determination, and that's been true in the United States since a famous case was issued by the most famous jurist probably of the early 20th century, Benjamin Cardozo in New York, where he said patients, as long as they're properly advised of their condition, risks and benefits of treatment, and alternatives to treatment.
You have joined the meeting as an attendee and will be muted throughout the meeting.
If you're on your phone, it's creating a lot of background noise.
Jen, we can't hear you.
Can you hear me now?
Yes, real good. Thank you. Because I think it's pretty clear that patients, when they're told something, as long as they were told in a clear way, they have a right of self-determination. And if they choose not to follow a provider's instructions, that's their choice, and there are consequences as a result of it. The critical factors I noted in both of these articles are to make sure that that's properly documented. And it may become, even though it's certainly not a desirable result, that because a patient is so non-adherent or so non-compliant that the doctor-patient relationship has irrevocably and irretrievably broken down, that it may be necessary after proper consultation with the patient to terminate the relationship.
Thank you for your great hosting, Rich. Thank you. We've had a great year with you all, and we wish you well and a blessed end of this 2023 and good health to all.
Thank you, everybody, for joining us. Have a great night. Bye-bye.